Morning, Miss Moss. Ma'am, you are charged with theft. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Yes, Judge. On February 13th, officers responded to a theft call at the Carters located at 1257 West Bay Area Boulevard. Dispatch advised that one female, the co-defendant, was concealing items in a bag and underneath her sweatshirt, while the other female, the defendant, was handing items. Claiming witness stated that the females were walking out of the store past all points of sale. Officers located both females walking out of the store located on the sidewalk next to the store, traveling west on foot. The co-defendant attempted to ditch the clothes where she threw them on the ground. Both females were detained. The co-defendant was identified as a juvenile. The complaining witness provided video footage of the theft, and the total of the merchandise stolen was $186.
Okay, hold up. This isn't just a one-time teenage mistake. Miss Moss already has another case, and now she's bringing a 15-year-old into the mix. This is where the judge's patience starts running thin. The court's not just looking at what happened, they're seeing a pattern. And that pattern, it's screaming trouble. Me too.
Do you have the co-defendant? Do we have it? That person here? Do you know? Do you have a cause number?
It's a juvenile, Judge.
Juvenile.
I believe that they would be in.
Okay. All right, Ms. Moss, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go to any Carters. Do you understand? You were on bond for another case, and now you've picked up a new case. Really, at some point, we're going to just revoke the bonds and make them high. If you're a danger to the public, there's only one place that we have. Do you understand, Ms. Moss? Did you want to apply for a court-appointed lawyer, ma'am? Okay. Do you mind filing no going to any Carters, please? And who is the co-defendant? Like, do you have a relation? Because I'm going to order no contact with that person.
Let's see, Judge, if I can find it.
Whatever.
I just have the identifying information, the initials IM. I believe she's 15 years old.
Is there, or did they list a relation of some sort? Do you know?
I don't see it on the danger arm. We don't have the evidence report back yet.
I guess we'll wait and let me see. So for now, ma'am, I'm going to have you sign a receipt with Victoria. I need you to fill in an application for me, and then we'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Do you understand? Okay, please. Deputy Manager, would you? Mr. Fleischer, you're charged with burglary of a motor vehicle. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were dispatched to burglary of a motor vehicle. The complaining witness Hargrove and complaining witness Vargas stated that their backpacks were stolen from their work truck. They stated that their vehicle was unlocked. A witness was able to provide ring camera footage showing a suspect walking across the street to the vehicle. A few minutes afterwards, it was found that complaining witness Hargrove's phone was used to send $400 via Cash App from the
Digital Forensics 101. Commit a crime, leave a digital trail, get caught. But using the victim's phone to send money to yourself? That's not just bold, it's self-snitching on hard mode. You might as well wear a shirt that says, I did it.
Complaining witness Hargrove's to the defendant. Officers were able to use this transaction to get a picture of the defendant through the Cash app. The complaining witness Hargroves sent this photo to a cousin and said that a friend knew the defendant from high school. Officers looked on social media sites and matched the pictures to the Cash App account.
This part is wild. The stolen phone is used to send $400 through Corrupto, the defendant. Then they ID him through his profile picture. If crime had a user manual on what not to do, this would be chapter 1.
Okay. Mr. Fleischer, so you also had a theft case. I didn't realize. So you're charged with theft. You're also charged with burglary of a motor vehicle. I'm going to find that there's probable cause to go forward on both of your cases. When was this? Was this in the middle of the night?
Sorry, Judge, 2:23.
So 2:22 in the afternoon. Okay. Mr. Fleischer, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. Do you understand? I'm going to do everything in my power to protect every single person of Harris County. And if that means making you bond, really high and putting you in custody, I'm going to do it in a heartbeat. Do you understand? Yes or no?
Yes.
Let's pause here. That line. The free world will be taken from you. That's not just poetic courtroom flair. It's a legal truth. Judges don't want to babysit repeat offenders. They want to protect the public. So if you're out on bond, act like...
How old are you, sir?
28. I work at a nursing home. I work at a nursing home.
So you do work.
Yes.
You want to apply for an appointed lawyer, sir? Okay, Deputy Miranda's going to give you an application for an appointed lawyer. I'm going to have you supervised. You're not to be in possession of any weapons as well. Do you understand? I'm telling you, behave yourself while you're out there in the free world, because if you don't, the free world will be taken from you. Mr. Fleischer, I think that you make too much money to have a court-appointed lawyer. Do you not, where do you live at home with mom or dad, or who do you live with? Yeah, I mean, you make a lot of money and you have literally no expenses, so I can't really give you one. So what we'll do is we'll give you time to hire a lawyer, and then we'll have you sign a reset. There's a gajillion and one lawyers out there. It's getting on the phone, interviewing one, finding one that you like. 99% of lawyers will put you on a payment plan as you go. So you just a couple $100 here, there, however, like anything in life, you get what you pay for though, right? They're the Mercedes-Benz of lawyers, and then you got the Yugo of lawyers. So just be careful, all right? Don't be a danger to my city, man. You know what I mean? Really. All right, come on. Oh, he already? So I guess we need him to sign conditions.
Right, so they'll just.
Okay, yeah, just take seat. We'll have a few conditions, then you're gone.
Yes, sir. How you doing this morning? I apologize for being late.
It's okay. I'm
Yes,
glad
sir.
you made it.
I'm just glad I was able to call and let you know because I was gonna come, no matter if I had to start
You're here now.
walking.
That's what matters.
Yes, sir. Amen.
Tell me your last name again.
Gary, Gary. My name.
Stop. Don't, please. You have the right to remain silent. Exercise that right. I have a bunch of DAs here, and whatever you say, that they can try to use it against you. So that we'll talk here momentarily, and then I'll let you get out. But I just don't want you to say something that hurts you, So, Miss Gary, you're charged with assault of a family member. You are facing up to a year in jail and/or a $4,000 fine. We're going to do
Here's the legal shift. Once visible injuries are confirmed by an officer, it jumps from he said, she said, into physical evidence territory. That drastically increases the likelihood of prosecution and makes the protective order that follows nearly automatic.
probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
On February 16th, 2025, within Harris County, Texas, officers were dispatched to a disturbance. The officers made contact with the defendant, who stated that she and the complainant were in a dating relationship. The defendant stated that she and the complainant were in a verbal argument when she stated that she did not like his comments. And the defendant stated that she assaulted him by punching, biting, and scratching him. The complainant stated that there was a physical altercation and that his injuries were in fact from the defendant. The officer observed several scratches, bite marks, and bruises on the complainant's body.
What is the relationship? Do you know?
They were in a dating relationship since October 1st, 2024.
Okay, so Ms. Gary, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond. Well, what I'm going to do is I'm granting a protective order. This is a protective order that identifies Mr. Ovanian as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand? This is a very serious court order that if you violate, the state can and probably will file a violation of a protective order against you. It's one of the worst cases you can pick up. So just go. Now, would you like me to provide you with a lawyer? Okay, I will give you a lawyer today. Everything that you wanted to tell me, tell it to the lawyer, and then they can, if need be, come and talk to me and we can try to resolve any issues that may come. I'm afraid of what you would say to me. They're going to hear it. It's probably not a good thing, Do you have any other questions?
I can go to jail for a year.
That's the potential punishment in this type of case. It's up to a year in jail and or a $4,000 fine. That is an assault. And this type of assault.
Yes, sir.
So, but that doesn't mean it's going to happen. You know, it just the potential. That's all.
Yes, sir.
So I need you to fill out an application for me though. So Deputy Echegoyen is going to give you an application. I just need you to fill it out. Do not leave until you sign our bond conditions, and then I'll have you talk to a lawyer here.
So am I still, do I have to pay anything on the PR bond?
No,
Okay, thank you.
not paying anything.
Thank you. Oh, well, they said I had a $90 court fee.
Don't listen to them.
God bless you, sir.
Good morning, Mr. Guzman. Sir, you're charged with criminal trespass. You're facing up to a year in jail because of the deadly weapon paragraph. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 2nd, 2025, at approximately 5:30 p.m., officer was dispatched to 1201 Spencer Highway in Harris County, Texas, for criminal trespass. Upon arrival, officers made contact with the complaining witness, who stated that the defendant attempted to stab him with a knife in the parking lot. Officers attempted to make contact with the defendant, and the defendant began running north through a strip center and tried to hide behind the strip center. The officers told the defendant to get on the ground, and he continued to walk toward officers and refused to take his hands out of his pocket. The defendant was arrested. Officers retraced the defendant's path and located a knife. The defendant admitted to having the knife and stated several males tried to jump him in the parking lot. The defendant stated one male tried to stab him and he was defending himself. Officers spoke to the complaining witness again. They said that he was in the store purchasing items, and the defendant was asked to leave by the employees in the store. Complaining witness stated that the defendant refused to leave and got into a verbal altercation with the employees. The defendant left, then waited outside in the parking lot and started asking people for money. The complaining witness told the defendant that employees had asked him to leave. The defendant pulled out a knife and brandished it in his hand and started walking towards the complaining witness. The complaining witness stated that there was about 25 feet between them. The witness saw the defendant walk towards the complaining witness.
So he goes back into the store after he leaves and after they told him to leave.
Yes.
Okay. Mr. Guzman, I'm going to find that there's probable cause to go forward with your case. Let me tell you that you're lucky that you're not charged with multiple felonies as well as it is, you know? I am ordering you not to be in possession of weapons and not to go back to this place. Do you understand?
Sure.
If I find that you become a danger to my community, I only have one place for you, Mr. Guzman. You know, really. I already have an affidavit from Deputy Randall. All right, so what I'm going to do is I'm going to have you go sign a receipt with Victoria. We'll have you take a seat in the jury box. I'm going to find you a lawyer here momentarily. Do not leave until you sign our bond conditions.
Sir.
You have missed court once. This is your second PR bond that they gave you. You will not get another one. If you miss court again, I'm telling you, your bond will, no more PR bonds. Do you understand?
Thank you
I'm
for,
giving you a lawyer. All you need to do is stay out of trouble. Make wise decisions.
sir, did I say,
No.
I just want to thank you for,
Just,
I called last week and I was supposed to come. I had a car problem. I didn't even think, thank you for giving me the second chance on the PR bond. You know, and I mean, it was, I called, but I understand.
you're out. All I'm asking you to do is make good decisions.
Yes, sir. Yes, sir. Yes, sir. I understand, sir.
Give you a lawyer here momentarily. Just, all right. All right. Hang tight. Let me have you sign the reset and then we'll have you go back.
Thank you, sir.
All right.
All right, then, next is case 6.
So no weapons, no guns.
When the judge says, I don't give a rat's behind, that's not just frustration, that's fury. DWI cases with open containers and sky-high blood alcohol levels. That's one way to lose your driver's license and the judge's mercy in one hearing.
Come on up.
Good morning, Mr. Murdoch. Sir, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 16th, officers observed a blue Kia Forte at 6300 Antoine Drive. The officers observed the vehicle make a U-turn where there's a prohibited U-turn sign. A traffic stop was initiated. Officers had previously observed this vehicle pulling out of a known after-hours bar located at 6314 Antoine Drive, Harris County, Texas. The defendant was a driver. Officers observed blood.
Driving with an open bottle, failing sobriety tests, and blowing a .19 more than twice the legal limit. The judge's reaction says it all. I don't give a rat's behind. That's not courtroom talk. That's a final warning.
Eyes and a strong odor of alcoholic beverage. The defendant admitted to drinking 2 Bud Lights. Standard field sobriety tests were performed, 6 out of 6 HGN, 1 out of 4 one-leg stand, and 4 out of 8 walking turn. The officer observed a 12-ounce Bud Light bottle of beer that was open and about 3/4 full upon an injury.
Drinking in the car while driving.
There were also 2 unopened shooters tequila and no console. The defendant consented to breath. TAC came back as .112 and .109.
I missed the basis for the stop. Can you tell me that one more time?
They saw the vehicle perform a U-turn in an area where the U-turn was prohibited.
Okay. Mr. Murdoch, I'm going to find that there's probable cause to go forward with your case. I would figure that it was damn elementary that you're not to have alcohol in the car while you're driving. I am now taking away your privilege to drive. You were not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. And I don't give a rat's behind what your excuse is if there's a burning building and you have to say 50 children. Do you understand? Every time you drive, it's punishable by up to 6 months in jail and a $500 fine every time you drive. Mr. Murdoch, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you if I find that you're using. Likewise, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer, sir? I'll have you fill out an application. I'll see whether you qualify. Heed this warning, Mr. Murdoch. You will not get another one. Do not become a danger to my city. All right?
Get this way.
Mr. Vieira, you are charged with driving while intoxicated, second offense.
These field sobriety test scores aren't just numbers, they're standardized indicators. And when you fail multiple parts, plus have an open bottle in the car, it's not looking good for Mr. Vieira. And telling officers you haven't been drinking while reeking of liquor. Classic courtroom contradiction incoming.
We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 24th of 2023, officers observed a dark sedan stopped at the light traveling westbound on Washington Street. And when the light turned green, the officer began to go, and the motor vehicle, a black BMW, almost struck the patrol vehicle on Shepherd Drive, causing the officer to hit the brakes. The motor vehicle then proceeded to drive southbound in North Shepherd, driving down a one-way street. A traffic stop was conducted. The officers approached the vehicle and observed a mild odor of alcoholic beverage coming from the vehicle and an open liquor bottle on the floorboard behind the passenger seat. The defendant was identified as Christopher Vieira. The defendant was observed to have bloodshot eyes and slurred speech. The defendant stated that he had not been drinking and he was just driving around. As officers were conducting the walking turns, the defendant stated he had surgery on his foot/leg when he was a baby and that something was wrong with him. HGN, 6 out of 6 clues, walk and turn, 5 out of 8 clues, and a one-leg stand, 2 out of 4 clues. During an inventory search, the officers found that open Espolon tequila bottle. The DXT was red and the defendant consented. The breath results were .133 and .1.
We've had a lot of issues with Mr. Vieira. And this case is now 700 days old. Take a seat for me in the jury box. Let's wait for the lawyer to get here. Good morning, Ms. Wells. Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On February 15th, officers were dispatched by the Harris County Transit Authority dispatch to a reckless driver in the 5200 block of South End Houston Tollway. Officers observed the vehicle failed to maintain a single lane and nearly strike 3 different vehicles. A traffic stop was initiated. Officer observed slurred speech and disheveled clothing. The defendant admitted to drinking. SFSTs were performed 6 out of 6 HGN for vertical nystagmus. Officer was not able to conduct the walking turn in the one-leg stand due to being unable to maintain her balance. The defendant consented to breath, came back as a .296 and .297.
Any prior DWIs?
No.
Ms. Wells, I'm going to find that there's probable cause to go forward with the case. Can you run your license as well, please? I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you consume anything, I'm going to revoke your bond and put you in jail. Do you understand?
Yes, sir.
If you have a problem with drugs or alcohol, now is the time to address it, because if it becomes an issue, I'm going to do it for you, and I promise you're not going to like the way that I do it. Do you understand?
It's about the drugs.
Okay, you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you don't have car insurance, you may not drive. Do you understand? Okay. Tell me, do you have the ability to hire a lawyer? I'll have you fill out an application. I'll see whether you qualify for an appointed lawyer. If you do, then we'll appoint you someone. For now, I'm going to have you meet with Victoria. We'll have you sign a reset. You'll eventually get with Fleischer your bond conditions, and then Deputy Miranda will give you an application there. Are you Miss Andre?
Yes.
Miss Andre, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you're not afford one, one will be appointed to you, ma'am.
On February 16th, officers were dispatched to a disturbance in Harris County, Texas. Officer made contact with the complaining witness who stated that he and the defendant had been in a 2-year dating relationship. The complaining witness stated that he broke up with the defendant and was trying to kick her out of the apartment. And the complaining witness was trying to force her out. The defendant punched him several times in the body, bit him, and broke a wine bottle on his head. The officer observed an open wound on the complainant's head and bite marks.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. There's a protective order that has been issued in this case. I would get to know it. If you do something to violate that protective order, the state can and will file a violation of protective order against you. Now's not the time to fight your case. I mean, if you need a lawyer, we can help you with that. Otherwise, you can go hire a lawyer and speak to them and they can help you fight the case. Do you have the ability to hire a lawyer, or would you like a court-appointed lawyer, ma'am? I'll have you fill out an application. I'll take a look at it. Hold on.
Oh, sorry, I thought. you were saying-
I'm issuing bond conditions on you now. You're not to have any contact. You're not to have any contact with this person, and I don't want you to have any weapons. If I find that you're a danger to my public, I'm going to revoke your bond and put you in jail. Do you understand? Okay, Deputy Miranda, do you mind? Okay, I'll have you sign a reset, and then we'll have you take a seat in the jury box.